On the record in the 53rd Circuit Court for the County of Sheboygan. We are providing public access both in the courtroom and also online. And first up, I'll call the matter of petition of the Sheboygan County Treasurer for foreclosure of certain lands for unpaid property taxes. It's file 25-9126CZ. And we have with us Ms. Weldon, the Sheboygan County Treasurer.
Good morning, Your Honor. As the Sheboygan County Treasurer and the foreclosing governmental unit for Sheboygan County, I've prepared a list of properties attached to the judgment of foreclosure I present to you today. If I may.
Yes.
This forfeiture list is much shorter than the list I filed with the original petition in June. Several properties have been redeemed and removed. A title search was conducted for the
Before this courtroom session even gets fully underway, what looks like a routine morning docket quickly turns into a fascinating look at how courts handle property disputes, foreclosure proceedings, and a surprisingly intense argument over a lakefront dock. At first, the judge addresses a large foreclosure case involving more than 100 parcels of land with unpaid property taxes. But the real drama begins when attorneys clash over a neighbor dispute involving a dock, alleged trespass, and years of arguments about property lines on the water. One side insists the dock has been sitting in the exact same location for years. The other argues the law simply doesn't work the way their opponent claims. And when the judge starts asking pointed questions about whether an amendment could completely change the scope of the trial, things get very interesting. Stay tuned, because this case becomes a lesson in how small property disputes can evolve into complex legal battles about liability, damages, and the fine details of property law.
these properties to identify all the owners with interest, and all owners were notified of this forfeiture property. I sent a sheriff's deputy to the property to attempt to notify the occupants of the forfeiture and upcoming proceedings. The property was then posted with a document containing all contact information. I've also posted in the local newspaper 2 publications, one on December 26th and one on January 2nd. I held a show cause hearing on January 14th at 9 a.m. I approved hardship extensions with payment plan arrangements. I included in the forfeiture list and the extension for 1 year on those. I will continue to grant hardship extensions and payment plans to prevent foreclosure, and my office continues to receive the 2023 tax payments. We're down to 101 parcels today.
Okay, very good. Thank you, Ms. Weldon. And based on your statements here today and my review of the file, it appears that the necessary steps have been taken, including the proof of service, proof of publication, proof of personal visit, an amended petition removing the redeemed parcels. And there has been notice and an opportunity to be heard to all parties interested in the properties to be forfeited. And the court file reflects no written objections to foreclosure. There are no parties in the Zoom waiting room that would be affiliated with this. The only parties I can identify as participating in other cases on my docket, and there's nobody in the gallery in the courtroom that is here to be heard on the foreclosure. Therefore, I would grant the requested relief under the statute and sign the proposed judgment of foreclosure, which allows redemption of any foreclosed parcels by March 31st of this year. I'm dating the judgment, today's date, February 9th. And do you want me to give it to the clerk for filing, or have the bailiff give it to you to bring it to the clerk for filing?
To the clerk would be great.
Okay.
Thank you, Your Honor.
All right, thank you very much, Ms. Weldon. We'll call Holderman v. Bruckman. All right, up next we have Holderman v. Bruckman, Coveton, Cisco, and Reeves. It's file 24-9044CH. Counsel, you want to state your appearances, please, beginning with plaintiff?
Yes, Your Honor. Joseph Sias on behalf of Mr. and Mrs. Holderman.
Good morning, Your Honor. Kevin Cleavorn. I appear on behalf of defendants Bruckman. The Bruckmans had a surgical procedure in Florida. I do not believe they'll be able to Zoom in this morning. Just me.
Good morning, Your Honor. On behalf of the Covetons, Chuck and Laura, and Ryan Cisco, I'm here as counsel.
All right, thank you. And I do have, we are scheduled for a bench trial on March 18th on the counterclaims in this matter brought by the Bruckmans and Covetons and Cisco defendants, counter plaintiffs. This is defendant Bruckman's motion to amend their counterclaim. I've reviewed the motion and then the brief in opposition filed by Mr. Zayas. So Mr. Cleavorn, anything you want to say in support of your motion?
Thank you, Your Honor. The counts that we listed back in 2024 are the same counts we have listed in the new proposed complaint that I attached to our motion. So there's really no new theories, no new claims, just the amount of time. When we commissioned the survey in 2024, paragraph 10 of our original complaint just referenced the year 2024, but the depositions all made it clear that the plaintiffs have been installing their dock for at least 3 and probably counting 2025 now 4 seasons right on the lot line. And as you'll note from the survey, their dock extends over into the defendant's lake space. And so, you know, the 2 issues of the trespass as well as the removal by Mr. Holderman of the mooring, that's count 2. Those are one and the same things. I did seek plaintiff's counsel consensus or concurrence, as again 2.118 leave is typically freely given and motion to amend is usually granted. But I guess what has been missed in this whole thing is originally in 2024 we pled for injunctive relief as well, so that if we could just get the plaintiffs to not put the dock, we asked for 20 feet in our original pleading. And again, I think that's something that, again, could have made this whole case cleaned up and gone away, but that's just seems like it's fallen on deaf ears. So that's why I think that is part of what the court needs to decide. Plaintiffs sent their response over lunchtime, and I was out of the office Friday afternoon, so I came in Saturday to read some of the cases they found. I do enjoy some of the old cases. So he cited Collins versus Gerhardt, a 1926 Supreme Court case. So I read that case. It was a Lake County case where the claimant had owned both sides of the Pine River and strung some barbed wire across the river so that he could fish his 120 acres. And so the court said, well, you can't really do that. The Pine River's been used for logging, and it was an entertaining case. I like reading the old case, but at the end of that case, our Supreme Court said in closing, again, saying he can't string barbed wire across the river, but he says, in exercising this right, I'm quoting from the case at page 49, in exercising this right, people cannot go upon the uplands of riparian owners in order to gain access to the water, period. If they do that, they are guilty of trespass, period. And that's 237 Mish at page 49, which is exactly what this case is. The dock of the Haldermans has gone over into the defendant's lake space, and that's how when they moor their boat, they're trespassing just to get on their boat. And the other case that plaintiff's counsel cited, I thought was wonderful for us when he quotes that a riparian owner from Holton versus Ward is entitled to use the, quote, entire surface of the water course for recreational purposes, close quote. That's exactly our problem, is that they are taking up the lake space of the defendants. And so, again, there's nothing new, no new counts. It's just the extension of time and the clarification of when they moor their boat, they're further intruding into the defendant's lake space. So again, there's no new counts, there's no new lawsuit, there's no new anything other than the extension of time. So I would ask that the court grant our leave to amend.
Can I ask you, Mr. Cleavorn, I was intrigued by the point that Mr. Zayas made with regard to your first counterclaim about the dock trespass. I granted summary disposition on liability to the counter plaintiffs on that claim. If I allow this amendment, by law that supersedes the prior pleading, and now you're pleading, more years of a trespass involving other years of placement of the dock when it's in and out and in and out, wouldn't that eliminate my ruling on summary disposition and reopen the issue of liability for the bench trial and therefore expand the scope of the proofs at that trial?
I struggle with that argument, and the reason I struggle for it is, when both plaintiffs say, yes, it's in the exact same spot, and it hasn't changed, and it's the exact same number of sections. There's just nothing new that I can foresee that would be a reason for more discovery. I mean, Mr. Zayas can talk to his clients all day long if he wants. There's nothing that would necessitate more work up of the case. So that
I'm not worried. I'm not worried so much about reopening discovery as I am about, the types of proofs that we're going to hear at the bench trial, because it seems to me if I grant your motion, then you've lost the bird in the hand of summary on liability, and liability must be proven at the bench trial, which is going to require additional proofs. Why would that not be so?
Well, I hear the argument. I'm just having difficulty appreciating the difference. And so forgive me if I'm a little slow on the uptake this morning, but when the liability of the trespass is if the dock was moving around and going in different spots, again, I could appreciate the argument a little bit, but when they've admitted it's been in the exact same spot, then I just struggle with there being anything other than extremely fine difference that I'm struggling to appreciate.
Okay. All right. Thank you. Mr. Zayas, your response, sir?
Yes, thank you, Your Honor. And I guess I'll start with Mr. Coltron's argument, made an oral argument, in the order that he did it, or at least I'll try to. First, it's inappropriate to float settlement offers during this process, and obviously I take offense with the same. Second, it would be completely inappropriate for the court to insert a 20-foot setback into this case. That's controlled by township regulation. Whether it crosses the line or not is one issue, but to say you got to stay 20 feet back is just ridiculous. He also misstates the holdings of the cases, or at least he misapplies them. So when he says that the older Supreme Court case, which holding is actually that you only own the soil under the water, you don't own the water itself or anything in it. So, the lake space, quote unquote, as he phrases it, it is irrelevant. And when he says that, yes, the newer case holds that a riparian owner can use the entire surface of the water for recreation. Yeah, that means anyone who lives on the lake can use the entire surface of the water for regulation, including the Holdermans. And when he talks about the Supreme
Well,
Court case,
not even them, but members of the public. If I put my boat in at a public launch, I can float my boat in front of the Holdermans, or I'm sorry, in front of the Bruckman's house all day long.
Yeah,
and I'm not committing a trespass. Perhaps my conduct could rise to the level of a nuisance under certain facts, but I would not thereby be committing a trespass.
Absolutely, Your Honor. And the only limitation is reasonable use. That hasn't been pled or argued today. So yeah, you're absolutely correct. As far as the uplands go, I think it's important because he also argued that we can't use his uplands to get to our boat, but upland is the land itself, the dry land. And the survey shows our dock, where it attaches to the land, is actually on our property. The survey shows it crossing over into the riparian bottomlands. And that's an issue we'll have for trial, and that's fine. But we don't use their upland for anything. So that's just false. Now, as to the motion to amend itself, one, it's untimely. I made that argument. We're a year after this deposition testimony took place. Even if this was news to him last March when he received the deposition, to wait until the eve of trial to say you're going to add counts is inappropriate. And my second argument, Your Honor, frankly, is that it's simply futile. We're talking about nominal damages at best. He can only claim for the bottomlands, and he's simply trying to buttress an already weak argument. So I would object to it on those grounds as well. And again, Your Honor, I also have no request or no inclination to reopen discovery in this case. Although I absolutely agree with what Your Honor stated earlier, that is, if this amendment is allowed, then we should at least go into liability, be able to go into liability for the years that weren't pled. Your Honor made a ruling based on that survey and the pleading that was submitted. And if he's going to change that pleading to allege additional years, then we need to go into that. Now, he's cited my client's deposition testimony, and it is what it is. Frankly, I think there was some confusion as to the questions, but that's all subject for another summary disposition motion. I think it's relevant that Mr. Colturn testified that it wasn't in the same spot, that it moved closer every year. So, it's kind of a factual problem, I think, for attorneys when they say, well, where was the dock 3 years ago? Well, here's where I think it was. So, we can have those, and this isn't a summary disposition hearing. We can have those, try those issues, and Mr. Cleavorn can ask his questions, and I'll ask mine, and the testimony will be what it is, and Your Honor can make the decision. But I think we at least get to go into it if we're going to expand the scope of what's going on here. And again, this is 1 year after this testimony took place. So that's my argument, Your Honor. If you have any questions, I'll be happy to address them.
All right, thank you. Mr. Hanson, before I ask for any rebuttal from Mr. Cleavorn, do you have a position?
I do.
Okay.
The original countercomplaint was filed in November 2024, and that states in both paragraphs 14A and repeated in 19A in requests for damages, an award of damages for each and every trespass by the Haldermans or their agents. And in subparagraph B, damages for the trespass by the Haldermans dock and their related water equipment in an amount the court deems just, but not less than $25,000. So that was pled in 2024. It doesn't limit in those paragraphs the damages to a particular calendar year. The proposed amended complaint uses the same language. I don't think that there's any merit to the counter defendant's argument that they didn't receive adequate notice of these claims, particularly when a year ago his clients testified that the use extended beyond one particular calendar year.
Okay, thank you, Mr. Hanson. Mr. Cleavorn, did you have any rebuttal argument?
No, I thought, and again, I thought when the court ruled in our favor back in August, and the court's order said that our remaining issues would be just only the amount of damages. So that's why I thought putting the plaintiff on notice, or what amounts to a reminder that they admitted it was not just the year 2024, there was a trespass, but they admitted that it was in the exact same location, exact names, number of sections for other years. So it seems like a de minimis request for amending pleadings.
All right, thank you. Well, the court rule does generally allow amendment to be granted liberally. Leave should be freely given. Um, There are some things about this case that just continue to stump me, and maybe I'm just slow on the uptake, and once I hear the proofs, I'll understand it. But this was not a dock case. This was a road case. And we've resolved that aspect of the case, and now there are these counterclaims for the dock and the mooring that, although they've been in the case the whole time, they were not the feature. They're not the feature presentation. It's like it's not even that this was a double feature movie show. This was more just a short. And when I issued rulings on the road matters, it never would have crossed my mind that we would 6 months later be dealing with the damages on the trespass. And I still, Mr. Zayas points out the testimony from the counter plaintiffs that, this didn't really cause them that much of an issue. And I mean, it's no surprise to all counsel that I've expressed before. My starting point is I have a hard time understanding how this is anything other than maybe some injunction, don't continue to trespass in the future, and nominal damages. I mean, I'll hear all the proofs and I'm not going to decide that without hearing the evidence, but everybody knows that's sort of my starting point. It's hard for me to understand how this is more than nominal damages. And I agree with the law that Mr. Zayas has cited about the water surface. I mean, really the only trespass is going to be on the bottom lands. And there's a procedural wrinkle here in that we're only like 5 weeks out from the bench trial for damages that I granted summary disposition on the claim. So I think an amendment to that claim would undo the ruling on liability, or at least allow it would. So granting the amendment, I think, would unnecessarily expand the scope of proofs at the bench trial. Also, although there's no surprise to the counter defendants about these claims, it's also true, and I think a relevant factor, that the counter plaintiffs could have brought this amendment or sought it anytime over the last year and not waited to the eve of trial, and thereby expanding the scope of its proofs. And also, I think there's a reasonable argument to be made that the amendment could well be futile, given the testimony of the lack of impact that the trespass had on the defendant's counter plaintiffs. So I think, although generally leave to amend is indeed freely granted, under these specific circumstances, I'm going to deny the motion, and we'll proceed to the bench trial previously scheduled on the counterclaims as they had been previously filed. Thank you, Mr. Zayas. As the prevailing party, would you submit an order?
Absolutely, Your Honor. Thank you.
Okay, thank you all very much. I'll see you soon.
Thank you, Your Honor.
All right, thank you, Mr. Hanson. You have a good day. Good morning, Ms. Padula.
Yes.
Can you tell me what case you're here on?
Yes, good morning. I'm here on the matter of Trudgeon versus Weckworth. We are set for a final pretrial conference.
Oh, yeah.
But we did submit a stipulated proposed order reflecting that the parties have resolved the matter.
Yes, and I think I signed that, which would have taken it off the docket. If you want to sit tight for just a second, let me just confirm that for you.
Absolutely, Judge. Thank you so
All right,
much.
let me put you in a waiting room for a second.
In the end, the judge makes a decision that highlights an important principle in courtroom procedure. Timing matters. Even though courts generally allow amendments to pleadings fairly freely, judges also have to consider fairness, efficiency, and whether a late change could disrupt an already scheduled trial. Here, the court concluded that allowing the amendment could reopen liability issues, expand the evidence needed at trial, and complicate a case that was only weeks away from being heard. So the motion to amend was denied, and the case will move forward exactly as it was previously structured, focusing only on the remaining issues already scheduled for the upcoming bench trial. It's a great example of how even small property disputes, something as simple as a dock placement on a lake, can evolve into detailed legal battles involving property rights, procedural rules, and questions about damages. Now we want to hear from you. Do you think the judge made the right call by denying the amendment this close to trial, or should the court have allowed the additional claims? If you found this courtroom breakdown interesting, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more real courtroom moments and legal analysis.